The Wall Street Journal recently had an article about the feuding heirs of former Texas Governor Dolph Briscoe's estate. Now, Dolph Briscoe, according to the article, is the largest individual landowner in the state of Texas. Everyone knows the King Ranch is the biggest ranch in Texas, but the King Ranch is not owned by an individual. It's owned by a group of investors, not even just one family anymore. Whereas Dolph Briscoe's holdings have remained in the family. In his will, he left equal portions of the ranch to his 3 children. And he wanted the provision that the ranch should always stay in the family. So how in the world did that end up in a will contest? It seems fair to leave your property equally between your 3 children. Hi, my name is Laura Hurd, and I have been practicing probate law and family law in San Antonio, Texas for 35 years. And I've seen many will contests. And in this case, the 3 children of Dolph Briscoe were Janie, who had 1 child, Chip, who had 2 sons, and Celie, who had 3 children. And Janie's daughter predeceased her. And so Janie had no heirs, and it is Janie's will that is involved in this contest. Janie, instead of just leaving half of her holdings to each of her 2 surviving siblings, decided to skip that generation and leave her holdings to the next generation, the grandchildren of Governor Dolph Briscoe. And when she originally wrote her will, rather than dividing it equally between the 2 siblings and then dividing Chip's half between his 2 sons and Celie's half between her 3 children, she had written it where each grandchild had an equal portion. And that meant that if the 3 children of Celie stuck together, they would have more power to outvote the 2 grandchildren of Chip. And they would have management over the property. Unbeknownst to Celie, before she died, Janie changed her will and swung the balance of power the other way. In fact, she cut out Janie's children. Janie cut out Celie's children entirely, which caused a lot of emotional hurt because her children were entirely cut out of her sister's will, and also completely switched the balance of power to Chip. He's now in full control. Now, Celie still owns 1/3 of the property, but Chip owns 1/3 and his sons own 1/3, and that gives that family 2/3. So Celie is contesting the will. Now, Celie, when she grew up, went to college in Dallas, married someone from Dallas, and has lived the remainder of her life in Dallas, raised her children there. Whereas Chip stuck with the land, has actively managed and worked on the land, and his sons are actively working on the land. So in one sense, it kind of makes sense that Janie would leave the management power with Chip because Chip is the one who's actually working the land. But in will contests, it often happens that there's a contest when the balance of power or the majority of property is not given equally to the people who are beneficiaries of the will. And in this case, even though Celie is a wealthy woman in her own right, she doesn't want to give up that emotional attachment to the land that her father owned, as well as it is quite a bit of money at stake. Oftentimes, will contests are so expensive that the entire estate goes to the lawyers in attorney's fees before it's over with, because the parties become so emotionally attached to their position for reasons that have nothing to do with money, but also because of the money, and they just cannot compromise or agree. And eventually the fight goes on and on until the attorney's fees eat up the entire estate. Now, this is a very large estate, so it's going to take a while for attorney's fees to eat it up. But at the same time, this contest has been going on since 2018. So in 4 years, I'm sure the attorney's fees have become quite large in that time. So what are Seeley's chances of winning? Can a judge decide, hey, it's just not fair that Seeley and her children got cut out of her sister's will? No, fairness has nothing to do with it. The probate judge cannot decide this case based on fairness. The only way that Seeley can overturn this will is to prove that one of the elements of testamentary capacity is unmet. In other words, that Janie didn't have the ability to make the will, the second will that she did. And in order to do that, Seeley's angle is that she's saying that her brother Chip authorized undue influence over his sister Janie. Undue influence is very difficult to prove. He has to have exercised so much power over Janie that she was essentially his puppet, that she felt like she had no will of her own. She would do whatever Chip told her to do. Seeley can't just prove that Janie was persuaded by her brother or that Janie had some more affection for her brother than for her. All of that is not enough. She has to actually prove that Janie didn't do it voluntarily, that she felt like she had no choice but to do whatever Chip told her to do. And that is something that hardly ever wins unless you can prove mental incapacity with some medical evidence or psychiatric evidence, which is not apparently involved in this case. So I would say that Janie's chances are pretty slim based on what was in the Wall Street Journal article. So the lesson that we learned from this is will contests are usually not worth it. Even if there is a large amount of money at stake, a large amount of money is going to end up going to attorney's fees. The family's going to be fighting for years and years. And in the end, chances are pretty good that the will is going to stand up. Because in Texas, you can give your property to whoever you want to in your will. It does not have to be a relative at all. You could have given the whole thing away to charity, and that will still stand regardless of how unfair it is, as long as you know what you're doing and you do it voluntarily at the time.